What's going on?
Okay.
What'd you do, bro?
I don't know.
No?
Probation. Apparently, they have a warrant for my arrest through the probation.
But how did they know that you were there?
They're watching the house.
So they're just confirming the warrant right now, bro, with Central Dispatch. As soon as that's done, I already looked it up earlier, so it's in there. You just got to do it. It's just a probation violation, bro. Hey, it's so nice.
829.
Yeah, 947 at 1710 Dogwood in Miss Tisco. Hi, how are you? How's it going, Ruben?
Okay.
What'd you do, bro?
I don't know.
No?
Probation.
Did you not check in or what?
I just went yesterday.
Oh, really? It's hot maybe or what?
Well, I got arrested in January, and
Yeah.
I got out in March, and I was already dirty for weed before I went in.
Yeah.
So I'm guessing that's what I had to do.
Yeah. That's weird. I appreciate you being cool, bro. We'll get this knocked out. I'm sure you'll talk to your PO and
Is
get it handled.
NCIC?
Yes.
Can you just give my stuff to my father-in-law? It's just my wallet, cigarettes, and I have a phone over here on this side. That's it.
You don't want to take your phone with you?
No, it's my wife's. My kids use it.
Is Sharina at work right now?
Yeah.
Is she still at the back on the books?
Yeah, as a matter of fact, could you call her for me?
Yeah.
That's all I want to use.
That's fine, bro. I'll give her a ring. Are these your papers?
Actually, they're my nephews.
You want me to give them to them?
Yeah, next to.
Kids.
I don't know.
Huh?
Hey, can you call
Who was
Rena right
supposed
now?
to get the kids? Who
Here you
was
go.
supposed to get my kids?
Who's supposed to
My
get your kids?
grandkids.
The ones
Right
that just
there.
came in?
Yes.
That's fine.
Right,
Sounds
yeah,
like
call
he's already got him.
I'm calling right now.
But he's got a probation violation warrant, man. I'm not sure why he got violated.
just got
What
it.
I
happened?
know.
You just already got
Tell
out right now.
me.
I know. But he's got it, bro. He's got to talk to his PO. I don't know what the deal is, bro.
What do with the kids? I got them.
Okay, sure, we got it.
Just call Rena's work for me.
Okay.
Yeah. Call the man, tell him we do that.
Can you dial it for me?
You want us to call him? That is Ruben stuff. Yeah. It sounds like he's on the phone with her, bro.
Yeah, no, he's with my son.
Oh, okay. Yeah, I'll call her. She may not answer. She's at work.
No,
but
she's good.
You want to see?
Hey,
Can I just wait?
let's have a seat, bro, and then that way we're not out here in front of everybody, you know.
On the 3rd of April, 2025, Las Cruces Police executed a felony probation violation warrant alongside the United States Marshals Service. 3 legal questions define this footage: the constitutional basis for the arrest, the Fifth Amendment risks of voluntary statements, and the due process rights at the revocation hearing. On the Fourth Amendment, a warrant-based arrest in a public place is constitutionally unassailable. The Supreme Court held in United States v. Watson that a valid arrest warrant carries its own probable cause determination. No additional justification is required from the officer at the moment of execution. The vehicle stop is equally sound. Under Warren v. United States, officers may stop any vehicle when a warrant exists for an occupant. The subject's presence in a third party's car created no Fourth Amendment complication. Under United States v. Knights, individuals on probation hold a substantially reduced expectation of privacy. Their conditional liberty status justifies greater law enforcement scrutiny of their movements and conduct in public. The warrant was issued under New Mexico statutes annotated section 3121-15. This statute authorizes the probation director to arrest a probationer or to deputize any officer to do so using a written statement in lieu of a judicial warrant. That written statement delivered with the probationer to the detention facility constitutes a legally sufficient warrant for detention. No judge is required to sign off at this stage. The arrest authority flows entirely from the probation supervision framework.
Hey, hon. Hey, they just picked me up. The cops did.
From where?
from picking up Luke from school. They're following us back to your dad's, and they pulled us over, and apparently I have a warrant through probation.
For what?
I don't know. It was a felony probation warrant.
Yes.
Yeah, so I guess I'm going to jail right now.
Where's the car?
The Elijah's at the house. Your dad picked us up to go and pick up Luke from school.
Oh my god.
Yeah, so I don't know. I don't know what's gonna happen, but I just want to let you know.
You have the wallet?
I gave it to your mom right now. She has it right here. They took Luke to the back.
Who picked you up?
The city cops did. They followed your dad from picking us up right now from the school.
So did they pull my dad over and then they got you, or what?
Yeah, well, we were getting off the car. I thought they were pulling over your dad. Apparently, they have a warrant for my arrest through the probation.
But how did they know that you were there?
They're watching the house. There's a bunch of cops out here right now. There's like 7 cops.
Where are you at right now?
I'm at your mom's house right here in the. I'm about to get taken. I just had this cop call here at work.
Oh my god.
So baby's at home. I don't know what's gonna happen, but I'm going in right now.
Probation violation, or
Yeah,
what is it?
I guess, right?
That's what it is, bro.
That's what he said. There's a warrant for my arrest.
And how come you didn't tell us?
I don't know. I just really went to go and report yesterday.
On the Fifth Amendment, throughout this encounter, the subject made multiple voluntary statements. He disclosed prior drug use during his probationary period, referenced his arrest history, and speculated about the current violation. None of these statements were made in response to questioning. Under Rhode Island versus Innis Miranda protections apply only to custodial interrogation, express questioning, or its functional equivalent. Spontaneous unsolicited statements fall entirely outside Miranda's protective scope. Any voluntary admission made during arrest processing is fully admissible at a subsequent revocation hearing. The right to remain silent does not self-activate. It must be affirmatively invoked. On the Sixth Amendment, the right to counsel does not attach in its fullest form until formal adversarial proceedings begin. Under Brewer versus Williams, that threshold is the revocation hearing, not the arrest itself. Requesting counsel at the arrest stage, however, is always the legally correct move. It eliminates the risk of further voluntary disclosures during transport and processing.
Yeah.
Elijah's pulling up to the house right here, to your mom's house.
Oh my god.
Yeah, so, I don't know, hon. If you wanna,
Can I talk to the cop, please?
he's right here.
I'm right here.
Yes, I'm sorry. So, did you try pulling my dad over and then you ran my husband's name, or what happened?
No, we knew that Ruben had a warrant. They told us that he had a warrant and asked us to come and pick him up for them. So we saw him in your dad's car, so we pulled him over here by your mom's house.
On Dubuque Street?
Mm-hmm.
Oh my god. And it's through the feds?
Yes, that's correct. Uh-huh.
And the marshals issued this?
Correct.
And it's just a probation violation?
Yeah, I don't know what the violation was. I don't know what Ruben did or supposedly did or whatever, but that's.
Can you please find out, and can you give me a call, please?
I can try.
I would really appreciate that.
I'll tell you, I did try and talk to his PO. Yeah, no, I understand. I tried to talk to Mr. Benegas earlier today to just out of curiosity to find out kind of what happened, but he hasn't returned my phone call yet. But if he does, I'll be sure to get a hold of you. But worst case scenario, I'm sure he'll be talking to you guys here in the next few hours anyway, because he's going to know that Ruben got scooped. So.
Oh my god.
Yeah, hon, just try to figure it out, okay?
Did you try to get Luke and Cameron?
Yeah, we just barely picked him up here. We were already coming back. He was going to drop me off at the house, and there was a cop behind your dad, and he followed us all the way over here. But Luke got taken. Luke's in the back over there with your mom. Tell Elijah to get the phone and the wallet from your mom and the other phone.
Oh my god. And how many cops is there?
There's 3, 4, 5, 6.
No, there's only,
And they're all
there's only four of
LCPD
us.
cops?
There's 1, 2 LCPD, and the other ones are like undercovers.
Are they marshals?
Yeah,
Like, what
there's
are
marshals. Yeah,
Oh my! Out of all days, as soon as I get to work, huh?
I know.
Son of a
But
bitch.
figure it out, hon. Hazel's at the
I'm gonna
house.
call your attorney right now.
Yeah, and then yeah. Okay, hon. Well, I love you. I'll talk to you later.
The controlling framework for what follows is Morrissey v. Brewer, the 1972 Supreme Court decision on probation revocation. Morrissey established 6 minimum due process protections at the revocation hearing. 1 written notice of the claimed violation. 2 disclosure of the evidence against the probationer. 3 the opportunity to be heard in person and to present witnesses. 4 the right to confront and cross-examine adverse witnesses. 5 a neutral and detached hearing body. 6 a written statement of the reasons for any revocation decision. 1 year later, Gagnon v. Scarpelli extended these protections to include the right to appointed counsel where the violation is genuinely disputed or the case is complex. None of these protections are triggered by the arrest itself. They apply at the hearing, which makes the arrest the moment when choices begin shaping the evidentiary record. 1 procedural detail warrants attention. The arresting officers did not know the specific nature of the probation violation at the time of execution. The law does not require the executing officer to know this, but an adequate briefing before execution is basic operational protocol. The failure to brief reflects an interagency communication gap, not an individual officer error. Additionally, the remand documentation was still in transit at the time of transport. Under Section 312115, the written statement must accompany the probationer to the detention facility. Concurrent transmission rather than prior receipt creates a procedural timing question worth monitoring. The standard of proof at a probation revocation hearing is reasonable certainty, not beyond a reasonable doubt. The court retains full discretion. Continue original probation, impose modified conditions, or require service of the original sentence. That discretion is exercised at the hearing, which makes legal representation at that stage not optional, but essential.
Tell the cops if you can please call me back. The name's not going to tell me anything.
Yeah.
By the time I get a hold of your lawyer, I'm not going to know anything. I need to know what's going on.
I know.
have the right to know.
I know, hon.
I'll try and call you, Sharina, as soon as I find out, okay?
Please.
Alrighty, ma'am.
Please.
But I gotta let you go so we
Please
can
do
get this
that
taken
for
care of. So
me,
that,
please.
Uh-huh.
At least that.
yeah, as soon as I find out, I'll try and give you a call back. All right?
Okay, thank you so much.
Love you, baby.
Love you too, bye.
It's okay.
You wanna leave your shades here, bro? You wanna take those?
Yeah.
Leave them here.
Hey, Elijah. I gave my wallet to Grandma. Okay. No. Grandma has the wallet and other black phone.
You don't got nothing else.
And no. And that was it. Okay. Just that, the wallet, and my phone. Grandma has it.
And what's your date of birth again? He spells his name a little bit different.
REU.
Yeah.
Hey, make sure you call Mom, okay? And I guess, I don't know. Talk to you guys later. I'll probably go to court tomorrow too for all that, right?
Yeah, I would think so, bro. It's a Friday, so they should be able to get you in pretty quick. See what's good.
Cool. Just go get the wallet and the phone.
Yeah, bro, you want to kick it in there? That way we can get all of us out of here. That way we're not drawing more attention to your in-laws' house, you know what I mean? All right, bro. Did you get the return yet? I just ran them on NCIC. It's
Yeah, they.
Oh, okay. Yeah, I just had it and I forgot it. Yeah.
Like, they gave me like the right spelling. They're like, oh yeah, that's not the right name.
Yeah.
Was that like shots where you knew I was picking up? God, how did you pick that up?
I'll tell you here in a minute.
Oh, I'm just that. I don't know what to say.
You guys can't have all the glory, Mark. Hey, bro. I know you guys got a bunch of kids. Are they at the other house too, or is anybody gonna need scooping up? Any of the kids need to be taken care of? Nothing like that, right?
No.
Okay, I didn't think so. I want to make sure because I know there's a lot of them. All right, thank you, sir.
So smooth.
You know what? I learned from the best.
It's your belly button.
I gave it to.
Oh, you don't need it or nothing?
No, he don't need it.
Oh, okay.
He said to give everything to you guys. So they're just confirming the warrant right now, bro, with Central Dispatch. As soon as that's done, I already looked it up earlier, so it's in there. You just got to do it. It's just a probation violation, bro. I don't know if he pissed hot or he said he just reported yesterday, so I don't know what it is. I texted the PO and he didn't text me back what it was for. So
Yeah, I think it was yesterday, huh?
Yeah.
So I'll be honest, dude. I don't know what the violation's for, but the warrant got cut. They asked us to go take a look. We just happened to see you guys driving around.
Yeah.
So
I went to school right there. I know, I see you guys.
yeah. So
I don't know it's for him though.
you thought we were watching you?
Huh?
You thought we were watching you?
Oh, not me. I ain't watching me for what? No, I thought when I came out of his house. I got pull over right there.
Over at the side of the road?
No, right there when you turn the lights on.
Oh, you were gonna pull over right there? Honestly, bro, I mean, we knew you had the kids. I'm glad that you just pulled up here. You know what I mean?
Yeah, I was gonna come home.
Yeah.
Yeah.
We figured that was gonna be the case, bro. I mean, the last couple times we dealt with Ruben, he's been cool. You know, you guys have been cool. So no need to make a big deal out of it. Good. Hey, thank you, sir. I appreciate you.
Anytime, sir.
Anything from us, Tristan? Just
General? Yeah, sure. The remand will be at the DC. The marshals
sign and everything.
The marshals are faxing it over there.
Thanks, homie.
Thanks, man.
Anyway.
The arresting officer receives an A. The warrant was confirmed through the National Crime Information Center and Central Dispatch before any contact was made. No force was used. The officer communicated transparently with the subject's family and disclosed the limits of his own knowledge. The grade does not reach A+ for one reason: no advisement of the subject's due process rights at the revocation hearing stage. That advisement is not legally required at arrest, but it costs nothing and materially serves the subject's ability to prepare. The subject receives a B+. Full cooperation with a lawful warrant execution is the correct response when no constitutional defect exists in the arrest itself. The grade falls short of A for two reasons. First, voluntary admissions regarding prior drug use during probation. Those statements were made without legal necessity and are now part of the evidentiary record available at the revocation hearing. Second, no request for counsel was made at any point during the encounter. Given the subject's stated uncertainty about the nature of the violation, early invocation of the right to counsel was both available and critical. The supervising agency receives a B. The warrant was validly issued. Multi-agency coordination was operationally effective. Transport was timely. The grade falls to B because executing officers were not briefed on the nature of the alleged violation before execution. The probation officer's failure to return the arresting officer's pre-execution call is the specific deficiency on record. 3 lessons from this footage apply broadly to any probationary encounter with law enforcement. First, silence is a right, not a strategy. The Fifth Amendment protects, but only if invoked. Voluntary statements carry no protection and full admissibility. Silence is always the safer default. Second, request counsel early. The right to appointed counsel at a revocation hearing under Gagnon v. Scarpelli is meaningful, but it must be requested. An attorney present before the hearing can challenge the sufficiency of the violation and ensure Morrissey protections are enforced. Third, cooperation with a lawful arrest and silence about the underlying facts are not contradictory. A person may comply fully with warrant execution while simultaneously declining to discuss the alleged violation or their prior conduct. These are independent choices with independent legal consequences. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.